Terri Gerstein started her career representing immigrant workers as a nonprofit lawyer before she joined the New York Attorney General's office, where she served eventually as Labor Bureau Chief. She's also been a deputy commissioner with the New York State Department of Labor, and of course is now serving as director of Harvard Center for Labor and a Just Economy within their state and local enforcement project. We are so pleased to have her here to kick off today's conversation on workplace justice and the role of the modern prosecutor. Thank you, Terri.
Thank you so much. And I'm so happy and excited to be here today with all of you talking about this really important topic. And what I'm going to do today is just give a broad overview of what's been happening in this space. And then we're going to hear about some particular cases and hear from a worker perspective and the U.S. Department of Labor. But I'll jump right in and just give, again, the very 50,000-foot view broad landscape. So criminal prosecutors across the country are starting increasingly to address a wide range of employer crimes against workers. These include wage theft, payroll fraud, which is when employers basically cheat on unemployment or workers' comp cases, labor trafficking, crimes related to workplace fatalities, cheating on prevailing wage projects, and more. And cases have been brought in a really wide range of jurisdictions. This is just a few of them, or many of them. There are more, but it gives you a sense, this map, which is from a couple of years ago, gives you a sense of some of the scope of where these cases are being brought. But I think it's useful before we delve into it to give a little bit of background on the context of violations. You know, what is leading? There are very, very high rates of violations of workplace laws, and what's leading to that? And so there are some decades-long trends that have given rise to the situation today in which there are such high rates of violation and really degraded and unlawful working standards. One is that there's really low union density in the private sector, around 6%. This is at historic lows, around the level that it was during the time of the New Deal. That's because our labor laws make it really hard for workers to form a union if they want to, which is, you know, a separate topic all its own. But how this affects enforcement is that unions basically act as on-site monitors within a workplace when there's a union in a workplace, and they also lobby for stronger laws. They lobby for funding for enforcement, and they generally just exert upward pressure on working conditions. Another factor, decades-long trend, is what has been called the fissuring of the workplace, that companies are increasingly using business models where they avoid the obligations of being an employer. So they'll subcontract, they'll use a temp agency, they'll use independent contractors, sometimes misclassifying workers, they'll use a franchising model. And this kind of fissuring, you know, it's the upchain entity that usually has the ability really to drive compliance and is larger and has an HR program and so on. But the lower level entities are the ones who are doing the direct employing, and they also have a thinner margin because as you have that chain, each entity in the chain has to take some portion of the money. And then we have forced arbitration, which an increasing number of workers, one estimate is around half, have to sign, and that prevents them from being able to bring cases in court before a judge. They have to go in secretive arbitration, and most workers don't bring these cases. And this is relevant because forced arbitration helps keep violations hidden and allows them to fester. And then in the context of all of this, we have really grossly inadequate resources for enforcement at the state, local, and federal level. I've put just two statistics up there, one about OSHA, that they would need 165 years to reach every workplace under their jurisdiction one time. And then the wage and hour numbers, the numbers from 22 may be updated. I know there's been an attempt to do some hiring, but that if you look at those numbers from 1948, there were 1,000 investigators for over 22 million workers. Now there are fewer in 2022 spring, there were fewer investigators for like almost 8 times as many workers. So this really sets the stage for high rates of violations. So a couple of the kinds of cases we're going to talk about, one is wage theft, and people who aren't familiar with it often ask, what does that term even mean? In some states, the term is defined in the law but more commonly, it's just sort of used as a colloquial term to refer to a set of practices where employers don't pay all the money workers are owed. So for example, they just stiff workers all together and pay nothing, or they pay sub-minimum wages, or they create 2 sets of books and don't pay overtime and have the overtime hours on a second set of books. They shave hours or tell people, work and then clock in, or clock out and then keep working, or they keep worker tips. There's a range of different kinds of practices. It's a little hard to measure the scope of wage theft because so much of it goes unreported because there are so many obstacles to reporting. People are afraid of retaliation. They don't know where to go, but the fear of retaliation and losing their job is really the biggest impediment to reporting among many. In 2017, EPI published a report that looked at just one form of wage theft, minimum wage violations in the 10 most populous states, and found that 2.4 million workers lose $8 billion annually, which averages out to $3,300 per year per person. And this is nearly a quarter of their earned wages. And so, if you look at that $3,300 per year per person, that you multiply that by a given employer, if they have 50 workers, it really adds up to quite a bit. And it adds up to quite a bit in terms of what it means in people's lives. We had a case involving home health aides who were not paid their wages and a worker got evicted. People can't afford to pay their bills when they don't get paid. So the amounts of money, even though relative to large financial crimes, they may be relatively modest, when they're aggregated over time and over many workers, it's a lot, and the impact on individual workers is considerable. This issue of the scope of wage theft has been getting more attention in the media. You can see Trevor Noah did a piece on it, and CBS just did a really great recent series. In both instances, they compared the scope of wage theft and the amount of money involved with property crimes like in this case, car theft, burglary, and theft, and found that wage theft really eclipsed, the amount of money involved eclipsed those other crimes. Then another kind of violation is what we could refer to as payroll fraud or misclassification. And that really, when we're talking about that, there's really 2 different phenomena we're talking about. One is employers misclassifying workers as independent contractors, sort of engaging in the fiction that they're independent businesses, which there are real independent contractors, but often employers basically pretend that someone is when there actually should be an employee. The other version is when employers just have someone off the books. And in both cases, this leads to the same clusters of violations: not paying payroll taxes, not paying unemployment insurance, and not getting workers' comp, and often violating wage and hour laws. The impact of this is obviously workers who are underpaid, but also honest employers who end up having to compete with bottom feeders who get a competitive advantage by violating the law. The DCAG's office did a study and found that construction contractors save 17 to 40% when they misclassify workers. And so you can see how that would, when you have an honest, law-abiding employer bidding on a job with someone who's violating all of these laws, it really makes it hard for honest employers to compete. And then there's also the other victim is the public, who ends up picking up the tab when employers evade taxes for important safety net and other public programs that are owed. Now, because all of you who are attending this training today probably somewhat accept the premise that these are appropriate matters for criminal prosecutions, but sometimes prosecutors may think, well, if someone doesn't get paid, isn't that just a civil lawsuit? Like, why is this criminal? Shouldn't they just go to small claims court? And I think it's valuable to note that, and I think there's someone who doesn't have their mute on. So because there's some background noise. So if anyone who doesn't have mute on, if you could mute yourself, that would be great. Thanks. But I was just going to note that prosecutions related to workplace conduct already routinely happen, but they happen when the employer is harmed or the business is harmed. So for example, if a worker embezzles from an employer, no one really questions like, well, isn't that a civil case? Why is that criminal? Like, how will we possibly find the resources to do this prosecution? It's sort of broadly understood that if that's something that should be criminally prosecuted. There are routinely cases involving workers' comp or unemployment insurance claimant fraud, when workers are fraudulently getting money. And so under those circumstances, it certainly seems appropriate or fair to use that same approach when there's crimes that occur in the workplace and workers are harmed. And in fact, it might lead to a greater impact. If one worker gets unemployment insurance, one claimant fraudulently, that's one person. But if you have an employer who's not paying unemployment taxes for dozens or hundreds of workers over a period of many, many calendar quarters, that adds up to a lot more money. And in fact, the National Coalition Against Insurance Fraud had a recently workers' comp task force, and they looked at workers' comp fraud, and they found, you can see the numbers on the slide, they found that the fraud committed by employers lying about their workforce in order to lower their premium was much, much greater than the amount of money involved in claimant fraud. I think it's also really valuable to note the deterrent impact of prosecution. I think this is really an area where criminal prosecution would have a very, I've been in this field a really long time. And I think that criminal prosecution has the potential to really move the dial in terms of employer compliance. Just giving a little bit of bringing the economists in a little bit. There are some economists who came up with a formula about compliance that will make sort of common sense to all of you, I think. In plain,
this is your 5-minute warning.
Okay. In plain language, it's that the likelihood of compliance depends on the likelihood of detection and the cost of consequences of getting caught. And so criminal prosecution increases both of those. What are the schemes involved in these cases? All of the things that are on this slide: making fake payroll records, underreporting employers, shaving work hours, demanding kickbacks, not paying wages, and often there are clusters of violations. So I'll give a couple of real little thumbnails of cases. In this, this slide sort of gives examples of the different kinds of wage theft cases that can happen. A Santa Clara County DA brought a case involving non-payment of overtime. The Michigan AG's office brought a case where an employer was deducting money for retirement contributions, but then just keeping the money and not remitting it where it was supposed to go. Harris County, Texas charged a homeowner with theft of services when someone did painting work after a hurricane and just the homeowner didn't pay them. And in the New York AG's office, we brought cases involving home health aides who were just stiffed and paid nothing for a month or two. Payroll fraud or misclassification cases, again, I think in both of these examples, you can see how it gives law-breaking employers an unfair advantage. In 2020, the Rhode Island AG charged a cleaning company that was a government contractor because they were falsely reporting $10,000 of payroll instead of the real number for workers' comp, and then that saved them a bunch of money that gave them a bidding competitive advantage. There was also a case brought by the San Diego DA's office where a couple had a business that had workers, housekeeping and janitorial workers working in hotels, and they didn't report them in order to save on taxes and workers' comp. Prevailing wage cases involve cases with government contractors who are supposed to pay a higher rate of pay. In 2021, the Pennsylvania AG's office brought a criminal case involving a huge Department of Transportation, state DOT contractor that basically deducted money, played with all the figures in relation to health benefits and retirement benefits, and sort of used money that was supposed to go to workers for the employer's own retirement benefits, among others. And in 2013, the New York AG's office brought a case in which a contractor working on an airport paid workers in checks and created perfect looking payroll records, but then took the workers to the bank to cash the checks and required kickbacks. And in that case, the bank teller was one of the witnesses. And then there are worker endangerment cases. We'll hear more about that from Lynn Feigenbaum, who's going to be speaking about a case that they worked on in Boston. Also in the New York AG's office, we brought some that involved child labor. What statutes have prosecutors used in bringing these cases? It really ranges. The first step is really looking at your statutes and looking at the conduct and seeing what might fit. There are, in some cases, definitions of wage theft, but in other cases, you can see all of these different types of charges that people have brought. So it's really valuable. Just read the statutes, think about what might fit. It's valuable also to look not just in the criminal and the penal law, but also within the labor law, because there might be some crimes or, some often misdemeanors, sometimes felonies, but there might be crimes articulated within the employment or labor law or unemployment insurance or workers' comp law. And I would also note that misdemeanors, I wrote, here, misdemeanors count. And I think with prosecutors often, there's a real focus on getting felonies. But in this context, the labor context, employers do not think of themselves as having committed criminal action. And if they see a news report that says, employer arrested for wage theft, that is what is going to get their attention and deter the violations. And whether it's a felony or misdemeanor is going to have much less of an impact in terms of that deterrence and changing of mindset about the importance of compliance.
This is your 1-minute warning.
So in terms of case referrals, where, one question people often have is, where do we get these cases from? There are two main sources in my experience in New York AG's office and most of the DA offices and AG offices that I've worked with. Most of them get their cases from either a variety of worker organizations, unions, advocacy groups, worker centers, or other government agencies like state and federal labor departments, and state workers' comp agencies. In both instances, it's really valuable to explain to them what you need for a referral, what a good criminal versus civil case looks like, and have some real conversation at the outset in order to avoid misunderstandings, because there's no reason they would know what a good criminal case looks like or what they should send you. If you want to learn more, we have virtual meetings every month. We have a working group focused on criminal prosecution of these cases. Our meetings are the second Tuesday of each month at 2 p.m. So you can reach out if you'd like to participate in those. And thank you for the time and opportunity to speak with all of you. And I'm really excited to see such great turnout and so much interest in this important topic.